Right, everybody. We might have some more people joining us, but we may as well get going as we'll be eating into your lunch break. I'm hoping you can all see us both. I'm Megan, and you should be able to see Sophie as well. Hopefully you can hear me, and at the moment Sophie's on mute. If you have any issues, you can use the chat box, and we can both see that as we go. So at the moment, it doesn't look like we've got any issues, which is great. So thank you for joining us today. As I said, I'm Megan, we've got Sophie as well. Sophie and I both practice PI, ClinNeg and inquests that go with those two areas of law. What we're hoping to do in our Law with Lunch today is give you a case law update. We've got 5 cases that we're going to run through, which just give you an overview of some things to be aware of from last year. If you want any more detail on cases, Sophie and I prepared a handout that was circulated at our Inquests Grandstand Event. If you couldn't make it and so you don't have a handout, just get in touch with us and we'll probably be able to circulate that to you anyway. And it'll be a good one to keep in the desk drawer to keep on top of things. I should say, you'll hear from me first, then Sophie, and we'll do a bit of swapping round. Between the two of us, we've probably got the most regional accents that PLP can offer. So at least you'll get some variation whilst you have your sandwich today. So I'm going to start with Boyce, and Sophie's going to talk about Guarani. I'll deal with Duval, and then Sophie will do Patton, and she's got a few points for you on Dylan as well. All in all, we'll probably run a little over 30 minutes, and if you've got any questions, just let us know. So I shall start with Boyce. 2022, so they're all cases from last year, so all within the last 12 months there or thereabouts. 4 of them are judicial review proceedings, 1 is a civil case, but Boyce was a JR case. Boyce was a case that on the facts arose out of Grace, who was 15. She was the subject of a care order under Middlesbrough Borough Council. She had a complex behavioural history. She was under medical care of psychiatry and complex childhood. Under the care order, she was placed in a private care home run by a private company in June 2018. Sadly, in September 2018, Grace committed suicide. She, on the 3rd of September, I think, was due to start her new school year. She did so. A couple of days later, she was excluded from school, having dyed her hair, I think the colour was purple, just before she went back to school because she wasn't looking forward to it. And then on the 10th of September, she was found having committed suicide and found at the home. There was an inquest into Grace's death, and after the PIR, there was talk about Article 2. The coroner invited written submissions, and in July 19, so shortly after the inquest had opened, the coroner ruled there was insufficient evidence that there'd been a real and immediate risk to Grace's life. So that's the operational duty. That revolved around her medical care mainly, and whether essentially it was known that she might take her own life despite her mental health struggles. But the systemic duty was left open. The coroner said, we'll deal with that. Coroner collated some evidence, all of which is summarised in the JR case. And we get to September 2020, so about 2 years after Grace has died. The coroner reviewed all the evidence and the submissions from the IPs and accepted there were issues with the systems and procedures operated by the council and at the home run by the limited company. But the coroner concluded it was not arguable that there was a real and substantial chance that improved systems and procedures would have saved Grace's life. So at the preliminary stage, the coroner accepted there were issues, but said on the causation point, she didn't need to pursue an Article 2 inquest because it wouldn't have made a difference on the causation test. The family, on behalf of Grace, brought 3 grounds under their JR proceedings. 1 was about the procedural obligation, 2, the systemic failings, and 3, the effect of Article 2 on the scope of the inquest. And there's no surprises, I'll tell you now, all 3 grounds were dismissed, but we'll take them in turn. Under the procedural obligation ground, the question was there an automatic Article 2 inquest on the basis that Grace was in state detention? She was under the care order of Middlesbrough Council. Boyce is a really good case to review the legal principles, as, to be honest, are all the cases that Sophie and I are going to talk to you about. If you pick up any one of them, if you have a comparable issue, you can work your way through the leading authorities summarised in these cases. So it's a really useful analysis on whether it's an automatic Article 2 right. But the judge held in Grace's JR proceedings, there is a very real and obvious difference between a child in secure accommodation who has thereby been deprived of her liberty and a child who is free to come and go, notwithstanding that if she simply left the home, police assistance would have been sought to find and return her to the home. So Grace fell into that latter category. She was free to come and go as she wished in the home. She wasn't subject to a deprivation of liberty. She wasn't under observation at the home. It was simply her place of residence, albeit under a care order. So the judge determined there was quite a difference between the LA having made the order, the court having made the order, and the LA being in charge of her care, compared to a situation where, yes, the LA is in charge of a child's care, but they go several steps further and there's a secure accommodation order. So on this case, the judge said no, simply being in state detention of some nature doesn't grant an automatic Article 2 inquest. So then the next question came under the procedural obligation. Well, if that's not right by way of analogy and extending the LA's care under the care order, was the home a public authority? So the limited company who ran it, did they amount to a public authority? So that Article 2 could effectively be applied direct to them under the state's obligation? The answer was very clearly no. The case of YL from 2007 was cited as still being a binding authority from the House of Lords. And the paragraph cited in Boyce by the judge is one from Lord Neuberger. I've put it on the slide in full because it's a good reminder to us as to what we need to think about for public authorities. So Lord Neuberger said, it's of particular importance in relation to the issue which we have to decide that a proprietor of a care home is not given significant or indeed any coercive or other statutory powers over its residents, whether they are in the care home pursuant to an arrangement with the local authority or otherwise. If proprietors had such powers, that would be a powerful reason for justifying the conclusion that the function was public in nature. Running a prison, discharging a statutory regulatory regime, maintaining defence and providing police services, which are plainly functions falling within section 6.3b, carry with them such powers. So in our case of Boyce, the judge said that YL was still appropriate, even though the distinction was a care home versus accommodation for a child. So all of those considerations about the powers that the home had over Grace were important in the deciding factors. Moving on through ground 2 for Boyce, that was about the systemic failings. So when you read Boyce and you read about Grace, there were criticisms of both the LA and the private home. There were several failings in Grace's case, and she certainly had a very difficult time. But in our JR proceedings, the question was about a causal link. Now, as we know, a causal link is required. So it wasn't enough that the coroner said there have been issues on a systemic basis. They needed to go further and be causative, or at least in principle causative, for Grace's death. And that causal link is whether the deceased lost a substantial chance of surviving because of the breach. Again, a good reminder that this is a lower threshold than the balance of probabilities. So it's a substantial chance of surviving. And on the facts of Grace's case, though there were systemic breaches by the council, the coroner on JR proceedings was entitled to conclude there was no causal link in fact. So again, it's nothing groundbreaking that we take from Boyce grounds 1 and 2, but it's a really helpful reminder when we start thinking about whether Article 2 is engaged and what that means for the impact on the person who has passed away. And round 3 in Boyce was the effect of Article 2 on the scope of the inquest. There were a couple of decisions to this effect last year, which considered what Article 2 means. When we get to the inquest, the coroner's asking questions, the IPs are asking questions. What are we thinking about? Is it more than a normal inquest? We talk about Jameson and Middleton inquests. What do those words mean? And the judge in Boyce gave us a very clear summary to say, when you look at the authorities, again, very good summary in Boyce, it's plain that notwithstanding the natural reading of sections 5.1 and 5.2, it tends to suggest the difference in scope of the two types of inquest. In practice, that's not the situation. The practical solution for inquest is to address the broad circumstances, especially if there is a possibility that Article 2 may become relevant in the future. In those circumstances, the inquiry should be broad enough to cover the ground for the coroner or jury to make the necessary conclusions. So what does this mean practically for us on the ground in the inquest? It means that we should be reminded that Article 2 isn't something that's decided once and for all at a PIR. It is something that can remain open throughout the inquest in the back of the coroner's mind, but it doesn't impact the inquest itself. It only tends to the conclusions that can be made and whether they can be judgmental in any way. So when asking questions, if there are any pushback from IPs or the coroner, how does this help me? Is this going too far? This is a good reminder that practically inquests can and should address the broad circumstances of a death. So when we look at how somebody came about their death versus in what circumstances, then this is a little nod to us to say we can explore a little bit wider, particularly if it might be Article 2. I'm sure there will be plenty coroners and assistant coroners, however, who would say to me, that's not the case in every inquest, don't push your luck. So if we have a road traffic inquest, for example, we need to be careful not to be pushing too far in our questions. I'm now going to hand over to Sophie for the case of Garani.
Thank you, Megan. Again, this is an application for judicial review, which was made by the family of the deceased, Mr. Salad. This is an interesting case. It is related to an Article 2 one, but it provides quite a lot of practical points. So I will take us through a few of the grounds on this, but essentially just as an overview, it's mostly in respect of procedural and fairness. As Megan's just been discussing about the scope of Article 2, it looks at the effect of that and the test for causation. And then finally, it's got quite a useful point in terms of when submissions are to be made for a Regulation 28 report. So it's just necessary to get the factual background before we delve into it. So Mr. Salaj, he was referred to the crisis team for mental health issues, thoughts of suicide in early 2018, and he had received treatment for that and was later discharged from the GP. He's experienced a number of difficulties at work, disciplinary proceedings and the like, and he was reviewed again by his general practitioner in December 2018. Now, a lot of this case then concerns about the facts when he then started to deteriorate in December 2018. So his family were quite concerned at that point, and they contacted the NHS single point of access, but due to a lack of staff unavailable to triage Mr. Salaj, it ended up that he wasn't triaged on that day and there was no phone call offered back to him. The following day, he was reviewed by his GP, and what's really notable on this occasion is that he never made any, when he was asked about his mental health, he said he had no thoughts of suicide. And ultimately, a few days after, I believe it was perhaps 5 days after, he was dismissed from work, and then he took his own life by falling to his death from a balcony, tragically. Just on the next slide, I've set out in brief the procedural background. It's just interesting in this case that there was quite a few preliminary pre-inquest reviews that were held, where the coroner actually initially decided that there wasn't an Article 2, this wasn't an Article 2 case. The coroner had said that Mr. Szilárd was not sufficiently vulnerable for the state to have assumed responsibility, and there was no basis for the GP particularly to have known that there was a real and immediate risk to Mr. Szilárd's life, and there was no apparent systemic failing. This was kept under review, and there was another push, further representations made at a later PIR, and the coroner did actually find that there was at least arguable systemic failings on that date when he was unable to be reviewed by or triaged by the single point of access. When reviewing this, the court who were dealing with a judicial review were actually quite shocked that this had been an Article 2 scope, had been widened, but of course they had to deal with it on that basis at the judicial review. Just looking at the next slide, just set out the grounds of challenge. Not going to really focus on grounds 5 and 6. Those particular grounds, just to give a brief summary of them, basically just found that the test of unreasonableness didn't apply. It wasn't a perverse finding that the coroner had made, and they didn't find any errors in the coroner's findings of fact. So really the more interesting ones, and I've taken these in groups as was in the judgment. So on the next slide, just looking at grounds 1 and 2, this was regarding procedural unfairness, and there was a lot of concerns, largely whether the coroner had been biased in approaching the inquest, and whether she should have recused herself because of that. It was submitted that there was a lot of questions and a general demeanour that gave that appearance, and that she was leading the witnesses. I won't recite the cases there, but these are in the judgment, and they just set out the test that the court was applying when looking at fairness in this case. So then moving to the next slide, that just sets out really quite a salient part of the judgment, that the coroner was entitled to approach this inquest with an open mind, but not an empty one. So she was able to form those preliminary views that she had, but then she was testing it against that witness evidence before her, which of course this is an inquisitorial process, so it seemed quite odd to have it so robustly cross-examined, as it did appear a little bit in this case. But the court were obviously emphasising that this is what the coroner was doing. So the leading questions they'd said hadn't particularly went there as a biased nature, but more so just that she was testing that evidence and the view that she had sort of initially formed. Then just looking at the next slide, this was grounds 3 and 4. This was largely in respect of the Article 2 factors that were in play. The court initially rejected the submission that an Article 2 inquest means that you have to investigate every single aspect of the case to the Article 2 standards. If you look in the Section 5 of the Coroners and Justice Act, it states where it's necessary to ensure compliance with the Convention. Of course, the scope remains a matter for the coroner, and in this particular one, the court looked through Jordan and UK, which sets out the minimum procedural requirements for Article 2, looking at things like authorities acting on their own motion, that the investigation was independent, there was a public scrutiny element, which may vary from case to case, and the like. And the court really accepted this was met, but they found the central issue really resolved around this GP appointment on the 12th of December. And looking at that, the coroner had addressed that in length within the actual narrative conclusion. And of course, we've seen in the case of Boyce that Megan referred to, you're looking at quite broad circumstances, but it's that point of it to make a necessary conclusion in that case. And in this case, they found that she had addressed those central issues that were raised under Article 2. And in any event, they'd found that she had performed a broader inquiry that was there. So this is just a useful reminder to clients, and when we're dealing with them, looking at the scope, and when it is Article 2, to manage those expectations of what can actually be dealt with. I've just put a reminder there as well about the causative test that was applied, because this was looked at again because the coroner had not been able to make a determination, and the court just was reminded of that test in Lewis. And just finally, on this particular case, it's a very minor point, but the family had submitted there was an error of law, that they decided that there was a Regulation 28 prevention of future deaths report without hearing submissions from the family. The court actually found there was no need for the coroner to actually hear submissions from the interested persons before making that judgment. There's no duty imposed on the coroner to do so before deciding whether that report arises. So again, this is just a practical point for managing interested persons, particularly families, expectations of what submissions can be made. Most coroners are more likely to listen to those, but again, it's not a prerequisite that they will listen to submissions on that basis.
Right, I've got the case of Deval next. As you'll see from our header on this case, Deval and the Ministry of Justice, this was not judicial review case. This was an appeal in a civil matter in the county court, arising out of the death of Billy. Billy had served, I think, 4 of his 8 years in prison for GBH, I think, and he was released from prison on licence. One of his conditions was that he had to reside at Fleming House between the hours of 11 p.m. and 7:30 a.m. It had originally been from 9 p.m, but I think for some good behaviour that was taken down to 11. Between the hours of 11 and 7:30, residents were locked in but could unlock their doors. So it wasn't a case that staff had to let them out, but as a starting point, they were retained in their rooms. They also had their medical care dealt with on a general NHS basis with community treatment. So they could go to the GP the same as everybody else. Billy's condition was that after 7:30 he could leave. So if he had a GP appointment at 11 o'clock, that was fine. He would attend in the community. So it was not akin to prison. It was just a residential condition, at least for the evening hours. The fateful day was the 21st of May 2017, where staff attended in Billy's room at about 8 o'clock. He was breathing, didn't wake up, left him to it. About 8:30, nearly 9 o'clock, Billy's family got in touch with staff at Fleming House and asked staff to wake Billy because he had a day of family events and they wanted to make sure he was up, changed, getting ready. Staff went in between the hours of 9 and 10 o'clock a handful of times. Billy wasn't rousing. He was breathing, but not responding. Their last visit in the morning was about 10 to 10. There were 2 members of staff shouting, clapping, flicking water at Billy, and he just was not rousing, albeit he was breathing, and they just left him. Figured he's all right, he's breathing, it's not our job to get him up. They didn't reattend until about 2 o'clock, so about 4 hours later. The staff tried the same action, shouting, clapping, bit of water, and Billy was not waking up. And so eventually they called an ambulance after this 4-hour delay of him being in the same condition. And when medical staff arrived about 3 p.m, Billy was pronounced dead and he had died of pneumonia. There was an inquest. The inquest was critical of some of the staff at the house, but as far as I read from the case, there were no findings made about Article 2. There might have been a judgmental conclusion, but that's the way we leave our inquests, no determinative findings. but Billy's family brought a civil claim pursuant to Section 7 of Human Rights Act 1998. Their claim was about Article 2. There was also an Article 8 claim, but I'll focus on Article 2. And they claimed there were breaches of both the systemic and operational duties in relation to Billy's case. The defendant, the MOJ, applied to strike out the particulars of claim / applied for summary judgment, and the tests being very similar. It was agreed that this was essentially a matter of law as to whether the claim had standing or not, because the defendant denied that a systemic duty existed in what were approved premises. So remember, Billy was not in prison. He was not detained in prison. It was a condition of license that he had to reside at approved premises for about 8.5 hours through the evening, of which he could release himself from, at least unlock his door, although he wasn't supposed to leave. The defendant also denied an operational duty because Billy was not in its care, so that's the care of the MOJ, and the defendant neither knew or ought to have known of a real and immediate risk to his life, i.e. he wasn't suffering from any known medical condition. There was nothing that staff ought to have been aware of specifically. The claim was simply about general deterioration, the fact they couldn't rouse him on these efforts. But the defendant's application for strikeout / summary judgment was dismissed at first instance. The appeal judgment is relatively brief when dealing with the first instance decision because it seems it was equally brief itself. The argument at first instance focused really on the definition of approved premises. So the difference between being in prison and on a license with approved residence. On appeal, it was a little wider. And I said there'd be a theme to our cases. The theme is there is no magic tool we can give you, but if you read Duval, it's a great summary of the law in all areas really of Article 2, but it goes through systemic and operational duties very nicely. And there were 4 grounds that the family brought, that the defendant brought in their appeal. 1, Billy was not in state custody at the time of his death, so the defendant said the judge was wrong to conclude that he was. 2, the judge failed to give clear reasons. 3, the judge failed to apply the relatively high threshold for Article 2 claims, and then ground 4 was about Article 8. The appeal was dismissed on every single ground. And the appeal judge said the first instance judge was right to dismiss the application for summary judgment / strikeout. The reasons for dismissing each of the 4 grounds are pretty brief, but what comes before those brief reasons starts at about paragraph 88 if you're scrolling down through the decision, and it is a great summary of the principles. So the reason the appeal was dismissed is the judge said there was a real prospect of establishing the requisite assumption of responsibility. And that was the focus, a responsibility. The mere fact of the location of the premises wasn't enough. And the test was much more involved than simply, was it an approved premises or not? I've got a couple of quotes which I think are pertinent to read out just to hammer home in our minds what we're thinking about when we have an Article 2 case that proceeds from the inquest through to a civil claim, and whether you are claiming or defending, is this something that can be dealt with by way of a summary judgment application, or do we need full evidence? And the appeal judge said that this continues to be an evolving area of law whose boundaries are not fixed. Accordingly, the court should continue to exercise considerable caution before striking out / dismissing claims on a summary basis. So for claimants in these types of claims, Duval is a great case and some good quotes to say this isn't a summary judgment / strikeout scenario. For defendants, there are some good quotes and sections in there that say, in this case of Duval, the pleadings and the evidence before the judge were fairly, they were undeveloped at the stage of the SJ application. The judge said, I don't quite have enough yet, and a summary judgment or strikeout application is not the time to make a determination of the facts. So that's handy to think of if you are a defendant and considering making an application for summary judgment. What material does the judge have? Is it enough? And if it's just on pleadings, the answer is probably not. Another quote from Duval, the appeal judge said, I'm satisfied there is a real prospect of success for the contentions that the defendant assumed responsibility for the welfare of Billy, and that its scope extended to protection from self-harm and drug abuse. To that end, I consider it properly arguable that the requirement for those on licence to reside in approved premises involves a sufficient form of state control outside the paradigm examples identified by the court in the cases of Rabone and Gardner. And I include this quote for us because it's an alternative conclusion, at least in preliminary form, to that of Boyce, when we were looking at the care of Grace in the children's home owned by a private company. What the judge in Duval was saying for the purposes of the civil claim is that we are thinking about assumed responsibility, and we are looking at state control, and questions in a civil case at the early stage is whether something is arguable. The judge doesn't need to make an early determination of these facts. Persuasive factors in the case of Duval were things I've already mentioned, so that Billy was able to leave even in his hours of residency between 11:30 and 7:30 in the morning. He was able to unlock his door. So where did the boundaries start to blur for Billy just because we passed 7:30 in the morning? He was still locked in unless a guard opened the door or he opened the door from the inside. And the judge again focused on the blurring of timing boundaries. The delay in Billy's case was from about 10 a.m. in the morning. And it was conceded by the defendant that had this occurred between the hours of 11 and 7:30, this would probably not be a case for summary judgment. So the judge again, stepping back, thinking it's probably too early to make a determination on the law, given the absence of facts, because it was just at a pleading stage, and considering that this type of claim under the Human Rights Act is still an evolving area. We don't have distinct categories under the operational duty or the systemic duty. We have lots of guidance. We have some categories that we know we fall squarely into. But other than that, it is developing. So if you get past your inquest stage and you get to a civil claim, on either side, don't feel pressure to force a resolution quickly. The answer is it's probably going to take a thorough hearing and a thorough look at the facts and the law to decide whether there has in fact been a breach of the Human Rights Act. I'm going to hand you back to Sophie for the case of Patton.
Thank you. So this particular case is a judicial review again, and this was brought by Mrs. Patton on behalf of her daughter, who tragically in this was found to have committed suicide. This really revolves around the coroner's decision that the Article 2 wasn't engaged. And it's quite an interesting one because Kiana, who was 16, she wasn't under the local authority care, but rather the submissions that were made revolved around whether the legislation had been properly engaged, and if it had have been, whether there would have been such duty and therefore a difference in outcome. Just briefly on the background, the relevant points are that she was under the care of a mental health team, but she was discharged in June 2019. She began living with a friend. Her mother, Mrs. Patton, was concerned about the accommodation. She'd chosen to reside with a friend, and had come about that she was smoking cannabis, and from this she had quite severe anxiety. Mrs. Patton had contacted the police, who in turn referred her to the council. So she was raising these concerns. Kiana went missing on the 23rd of October 2019, and sadly her body was found the next day. Now, there were a number of pre-inquest reviews where an Article 2 submissions were made that should apply, and that's really what the subject of this challenge was. Mrs. Patton had argued that there was an arguable breach of the state's systemic duty, as described in Morahan. If we just look at the next slide, she'd done so in that, saying there was a systemic duty essentially by relying on this section in the Social Services and Wellbeing Act, that essentially we were looking at 76C and 3, that there should have been, the local authority should have assumed care by essentially putting her in, dealing with the accommodation. And Mrs. Patton had relied on this as the gateway to this general duty that was owed, that had this been properly applied, as I mentioned previously, they would have assumed that responsibility. If we just go to the next slide, these are the, so just briefly before I just go on to this ground, there were 3 grounds for judicial review, but really this is the pertinent ground that I found in the judgment. As I said, Mrs. Patton had said that in order to have this general duty, the gateway was this section 76, and had that been properly applied, that would alter the outcome. And the council had argued the operational duty hadn't been engaged, and they'd made it, they'd said that this section 76 legislation, it was owed to a wider group of children, and it was triggering an operational duty rather than a general duty. Well, the court had looked at Raburn and looked at the fact that the relevance of the assumption of responsibility for the state for the individual's welfare, but they looked at the factors in that and found that was relevant to the operational duty rather than the general duty. And in turning to the general duty, there's wider circumstances that are in place in respect of legislature and administrative framework to protect that right to life. And essentially the court had found the coroner should have preceded this, not relying on section 76 of the Act being contingent on whether there was a duty. He should have actually looked at whether there was a general duty between Kiana and the council themselves, but also that between the police and the health board. And once that had been looked at, then looking at whether there was arguable breaches. Of course, there's quite a low threshold for that, bearing in mind the key distinctions, as we know, that the systemic ones, that systemic duty doesn't apply if it is individual failings. And only then was it said that it should be addressing that causative test of whether there was proven those breaches meant there was, as Megan had referred to in Boyce, a substantial chance of a different outcome. So essentially they'd taken it in steps that are put there, the general deal with the general duty, whether that actually applied, the breaches, and then causation. And the ruling that the coroner gave didn't deal with those. Interestingly, the court also found, and there was a case of Salford City Council, that if there's a dispute whether that legislation does apply, the coroner was actually obliged to conduct his own assessment of that legislation. And they found that given the brevity of the reasons in his conclusion, it was hard to find and have confidence that the coroner had actually undertook that exercise. The family in this case had asked if they'd invited the court to make a determination on whether it's an Article 2 skirt, but the outcome was that it was quashed and remitted to the coroner for redetermination. So again, this case just provides that useful step-by-step basis when looking at general duties, and it just really shows that whether the duties owed isn't contingent on any legislation. It's really looking at the broader circumstances. The next page I'll deal with, sorry, the next slide is very briefly, it's just the case of Dylan. I'm not going to say too much, except that this is quite a useful case if you're looking at making submissions for prevention of future deaths report or advising interested persons on whether a coroner is likely to grant those. And it's really just looking at what action should have been taken. That's what the Coroners and Justice Act says. And the court had endorsed guidance where the Prevention of Future Deaths report should be meaningful and wherever possible have practical effect. So it's really looking at whether there was a realistic prospect that it'd be acted upon. In the paragraphs that I've referred to there of the judgment, they set out in detail why the coroner based her findings on not permitting a Regulation 28 report, why that threshold wasn't met for it, and the court's finding on each. But essentially, they found that she'd not been irrational in refusing that, and that, as I say, we're looking at that, what actual effect it would have.
Super. Well, those were our 5 cases that we thought it was helpful to highlight and go through some principles of. There were plenty of cases last year, and the case of Dove heard last week, and some updates on the Chief Coroner's guidance, which we put at the end of our slides just there. So with that, it's just for us to say thank you for attending. If you have any questions, let us know. But as we said at the beginning, if any of you couldn't attend our grandstand event and would like a copy of our case law update handout, you need only get in touch, and I'm sure we can get that circulated to you. So thank you for attending, and enjoy the rest of your lunch.
Thank you.